Simon mo akwa babium eba ye channel yi so na se ne de betu manim se eye Supreme Court and NDC for atam eye an EC ni MPP for the Mako Court about some Re-Collation be a course so on about 9 constituencies be an akamuno. Supreme Court enya the verdict about abontin na was say eye NDC for the kind of assembly call eye High Court no NT or ma 17 was say be kwan ma mo bi so o mon san ko na High Court no mo kwan no nti o ma sem aye o mo de bae no na eno no chi no we declare a year to a year constituencies and they will say a year results and say collected results no and then one understand then they valid a year Ahafo no any Nsawam then they will declare say a year valid engineer says they omu declare and for as a Re-Collation course no yemfa and one is na other 4 constituencies need they or say on one sanko High Court na High Court NT a year NDC for some of the betu is that Mudi kind of go in the High Court NT or maximum of the buyer na or make a verdict. We know in some way free Supreme Court a buyer or bra here in some copy court say Re-Collation no and yet and mass and no constitutional no in some way Supreme Court debate to grant ever corner quakuti Supreme Court the judgment or the buyer after say in some baby and as we take a fanning in some before say ever corner. Subscribe and like share them out for media. Yedi ewo ye channel so yen kwani nkoti mwe madamasi.
We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam ALJAZEERA and Ahafo North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024, the court are hereby set. For the avoidance of doubt, the orders of the High Court in respect of Nsawam ALJAZEERA and Ahafo North are not affected by this order, our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwige Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. Interested parties say that because Mr. Godwin Edwidge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam and Ahafo North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam and Ahafo North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed. Yeah. Now, those which have been quashed. Sorry. Those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I'm sure, I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, ALJAZEERA Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
Before you go, and we're grateful that you could at least follow through proceedings for us. So Lord Edwasari is our man in court, and we'll try and pick the thoughts of some of the key actors in that court. The ruling was a few minutes ago where the Supreme Court, let me just run that by you quickly if you're just joining us. Out of the 7 that had been declared by the Electoral Commission after Re-Collation, the Supreme Court has quashed 4 of them and upheld 2. Now, the 4 that they have quashed are Okaikwe Central, Ablekuma North, Tema Central, and Techiman South. And there are 2 of them that have been upheld, which is Nsawam and Ahafo North. Kojoga Daudu is one of the legal members of the NDC. Let's listen to him.
High Court judge, whilst hearing the mandamus application, had noticed that the applicants, that is the candidates for Okaikwe, Tema Central, and others, they had filed and the judge was put on notice that we had an interest. They had filed this earlier, but did not do. So the court says that they had notice, and once you had notice, you should have heard them. You should have joined them and heard them, notwithstanding the fact that the rules that they are talking about, because hearing somebody, natural justice has become a constitutional level. It's been elevated to constitutional right. So even if administrative bodies, where they use the WAEC example, Awuni versus WAEC, that if they are bound to give a hearing notice to somebody who has an interest, then how much more a court, high court, that will not listen. So that's why they gave the decision that whilst there was evidence that those had been declared already or something, they should go back. And that's why they've abridged the time. Let the court allow them to file the affidavit, then they can make an argument, they can be heard. Legal argument can be heard, whether the mandamus should be granted or not. But to also, that there should be some fairness and impartiality, because already there is some kind of likelihood of bias they are talking about the judge. So it should be sent to another judge for the matter to be heard. So all the processes have been that it should be ready before the 31st, and the 31st we have to go to court to hear that matter.
Does this tentatively mean that, as it stands, the MP-elects of these 4 areas are still MP-elects till maybe Tuesday? Is that what it means?
Yeah, yes, that's what it means. So we have to go. Then once they go, that's why it says that for Nsawam and Ahafo, it was a collation that was incomplete, and they have done it. So that's why those results will stand. But for the other 4, they have to go back to the High Court, and the High Court will now hear the application.
Okay. All right, thank you very much. That was Victor Adaudu, one of the lawyers of the NDC. We'll still be getting more reactions from the various quarters. I see Gary Nimako. Let's get Gary speaking. We're going to get his thoughts. He's speaking for the NPP.
All right. The EC did collation and declaration in affected areas, and they just said they were not heard on the application. They came to court to say that they were not heard. The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response. Okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation and declaration. That is the point. So it's not about re-collation. So this word re-collation, there is no collation at all.
Finally, Nsawam and the other one, Ahafo South.
Yes.
If the NDC decides to contest that again on a separate platform, what will you do?
Well, that is up to them. The court has spoken already, so that ends the matter.
You face them?
Face who? I'm talking to them. NDC, they are not enemies. We are not fighting. It's a question of the brains. We are not fighting.
The court is concerned about peace after today's ruling. What message do you have?
No, not after today's ruling per se. It's peace post-elections. You realize that after these elections, there have been a lot of post-election violence. We don't understand. There must be peace in the country. If we won elections, what about the destruction of state properties and all these things? It's not good. So let's all learn to abide